So in 1970, they created no-fault divorce, and and I believe that all of the other states have the same kind of provisions as Iowa still does, where you allege in your divorce petition that the legitimate objects of matrimony have broken down and there remains no reasonable hope of their reconciliation. No one has bothered to define in law legitimate objects of matrimony, and this has turned into just an automatic license to get divorced as soon as one spouse asks for it. There's no ability in the other spouse to contest the divorce, but law doesn't say that. And for that reason, I have been trying to create legal briefs to help people who want to contest their divorce. Here's a song about why this is important. Big brown house, a family, mom and dad, a brown puppy, 4 children. Mom wrote books, dad taught in school, kids grew by the golden rule, child heaven. But parents play, children pay, parents stray, children pray. One of the saddest things we see today, the home where parents play and children pay. Well, let me give you some ideas from the legal brief that I have written. And this brief will just my right to review such evidence with testimony of witnesses and cross-examination. Whoa, did you hear what I just said? In this legal brief, I'm demanding my right to set forth the testimony that the divorce should not be granted, and in support of, in the process of giving that evidence, I want to be able to counter that evidence with my testimony about why the legitimate objects of matrimony have not broken down. I want to call witnesses, and I want to cross-examine my spouse that is petitioning for the divorce. Going on with the legal brief. I deny my spouse's ground for divorce. Count 2, number 6 of his answer, that there has been a breakdown of the marriage relationship petition. He files a petition, and I'm saying, and he's in the petition, he says there has been a breakdown of the marriage relationship to the extent that the legitimate objects of matrimony have been destroyed and there remains no reasonable likelihood that the marriage can be preserved. I will exercise my right under Iowa law to present rebuttal evidence. I also deny that the petition has these numbered paragraphs, so maybe the next paragraph will be number 7. I deny number 7, that the marriage cannot be preserved by the appointment of a conciliator, in other words, a counselor. All I want is a fair chance for each of us to voice our concerns and have a fair chance to respond to each other to clear up multiple misunderstandings. I pray for reconsideration on this point, as I want with all my heart to do all I can. It is premature to assume nothing can help before something is tried. Iowa Code 598.5, paragraph 3 requires that, quote, the allegations of the petition shall be established by competent evidence. You hear that? The allegations of the petition shall be established by competent evidence. But the petition contains no evidence at all, and therefore, if Iowa law were followed, claim number 7 should be dismissed on its face. It has become customary to equate the allegation itself with evidence, but by listing the requirement that the petitioner allege this claim in 598.5 paragraph 1G, and by separately listing the requirement that this allegation be established by competent evidence in 598.5 paragraph 3, it is obvious that Iowa lawmakers in 1970 understood allegation and evidence to be two separate things, and they demanded both, even in dissolution cases, just as they demand and is routine in every other kind of case. Now, at trial, Iowa law requires that the court be, quote, satisfied from the evidence presented. That's Iowa Code 598.17. Before the dissolution may be granted. If no competent evidence, or even any evidence at all, is presented at trial, as has become customary in dissolution cases, theoretically the allegation should be easy to counter if the law is followed and rebuttal evidence is allowed and considered. I am prepared to prove with evidence and argument here and by testimony and cross-examination at trial that the legitimate objects of matrimony have not been destroyed by any reasonable definition of legitimate objects of matrimony, and there does remain a very reasonable likelihood that the marriage can be preserved. However, although the legitimate objects of matrimony have not been destroyed yet, granting of my spouse's petition will destroy them. I plead with the court not to destroy the legitimate objects of matrimony by granting his petition for divorce. Legitimate objects of matrimony. Let's see if we can define it. My hurdle is that in the 43 years since Iowa law has required that the court be satisfied from the evidence presented that there has been a breakdown of the marriage relationship to the extent that the legitimate objects of matrimony have been destroyed and there remains no reasonable likelihood that marriage can be preserved. Iowa 598.17. There has been no attempt to define the legitimate objects of matrimony, creating confusion about the nature of evidence concerning them and reducing the explicit requirements of the law to mere lip service. This is a serious omission, considering that, number one, Iowa 598.17 explicitly says the court must be satisfied from the evidence presented that there has been a breakdown of them. And number two, Iowa 598.17's second paragraph says it is possible for the petitioner to, quote, fail to present satisfactory evidence that there has been a breakdown, in which case the divorce will only be granted if the respondent completes the grim picture. This could not more clearly corroborate the legislature's expectation that the evidence of breakdown to be sufficient to authorize the court to sever the marriage bonds must be more than an automatic rubber stamp. It must be at least somewhat compelling or satisfactory, and in fact it must be enough so for the court to be satisfied. Now, in every other legal context, any requirement for evidence is understood to require the opportunity for rebuttal evidence through evidence from the other side. Let the other side be heard through pretrial briefs, depositions, mediation, and at trial, testimony and cross-examination. Testimony of witnesses. Now here's the second paragraph. 598.17, second paragraph. If at the time of trial petitioner fails to present satisfactory evidence that there has been a breakdown of the marriage relationship to the extent that the legitimate objects of matrimony have been destroyed and there remains no reasonable likelihood that the marriage can be preserved. The respondent may then proceed to present such evidence as if the respondent had filed the original petition. Well, there was a court case in 1975, Kraft versus Kraft, which has never been overturned or challenged. This is an Iowa case, and which quotes code sections which have not changed. And this case says, the statutory requirement for dissolution of marriage, that marriage breakdown be established by competent evidence, is mandatory and may not be satisfied by parties' stipulation to that effect. Stipulation is a written agreement by both parties. When the petition says, I allege their legitimate objects of matrimony have been broken down, etc., and then the respondent, as is routine, puts in response to the court way before trial saying, I admit that the legitimate objects of matrimony are broken down. That's routine. The lawyers say that you're supposed to do that. You're not supposed to say, no, I don't admit. So that's a stipulation. And this 1975 case says even a stipulation does not satisfy the evidence requirement. A stipulation, a written agreement by both parties that something is true. Okay. Now, in other words, even if both parties agree in writing that the marriage is hopelessly broken down, the court can't just automatically give them a divorce without additional evidence of the breakdown. The court is given jurisdiction to determine, for example, that both spouses are premature or even immature in reaching that conclusion. The court has as much of a role in pressuring the parties to reason and to rule on whether evidence is relevant or persuasive to a reasonable person as it would in a dispute between neighbors or over inheritance. How much less ought the statutory requirement to be satisfied when one spouse merely alleges it is without evidence while the other spouse denies it is with supporting evidence? Kraft, the 1975 case, continues. Respondent's first assignment, that is the first concession of the response, asserts a failure to comply with 598.7 and 598.8, the code. The code provides, quote, the petition must be verified by the petitioner and its allegation established by competent evidence. Paragraph 8 provides, hearings for dissolution of marriage shall be held in open court upon the oral testimony of witnesses. Iowa law says you get to have witnesses. Both parties to contest the divorce. Both parties, Kraft continues, both parties appeared at trial and testified. Neither testified as to the grounds for dissolution. The provisions of these two paragraphs are mandatory. The parties are not entitled to dissolution merely because the rule is of ancient origin and has obtained in Iowa from earliest times. In Leicester versus Leicester, 1855, we considered a divorce sought on a ground authorized by the 1851 Code that the parties cannot live together in peace and happiness. A little footnote here, my comment. Peace and happiness are, of course, relative terms, but they're interesting standards. Not only are they relative, but they are conditions which my spouse and I agree as Christians are not governed by external circumstances, but by internal choices and faith. Contentment under all possible circumstances is a thing one learns, according to Philippians 4:11. A song, even in the night, is what one finds who seeks it. according to Job 35, verse 10. Now, that's why a 3-year marriage has so much more going. That's why a 30-year marriage like ours, this again a hypothetical. This is a hypothetical brief, and of course, not everyone has been married 30 years. But if you have, this is something you could say. That's why a 30-year marriage has so much more going for it than a 3-year marriage, when we were young and we had not learned to be content with even the slightest disturbances. Okay, let me return to quoting the Kraft versus Kraft case from 1975. We held, the law requires that the court shall be satisfied that it shall be made fully apparent to the court that the parties cannot live together in peace and happiness, and not that the parties shall be satisfied. It is not alone the immediate parties to the proceeding that are affected, but in most instances the care and disposition of children and property, and in all cases the proper moral order and peace of society will and must arise. The principle and the reasons for it persist. The legitimate interests of the state in marriage termination were recently recognized in Sosna versus Iowa. I'm still quoting the Kraft case, decided on January 14th, 1975, earlier the same year as Kraft. Respondent is right in arguing the requirements of 598.7 and .8 cannot be satisfied by stipulation. Okay, that's the end of the quote. We're still quoting. Respondent Kraft had stipulated to the ground of dissolution, but had later, presumably on appeal, objected that a stipulation was insufficient evidence, with which the Supreme Court agreed. I'm sorry. That's my summary of Kraft. That's not Kraft itself. Okay. But that's what happened. Kraft had stipulated to the ground of dissolution. The person responding. The petitioner is the one that files for divorce. The respondent is the one that gets divorced. The one that got divorced stipulated to the ground of dissolution in the response, the written response, but later on appeal objected that that was insufficient evidence. So apparently they got to read the law and say, wait a minute, I don't have to agree to this. So they challenged the divorce. So the Supreme Court agreed the stipulation was insufficient. So what did happen? Did the respondent Kraft change his mind, or was the stipulation no more than the required statement in the petition compared with the routine concurrence in the response, which lawyers automatically draw up? In any case, the court agreed a stipulation was insufficient evidence. But the court was satisfied with the evidence presented because a neighbor testified that the marriage was toast, and the respondent at trial offered no rebuttal evidence. So it is clear from the court's remark that, number one, the respondent's failure to rebut the evidence was a factor in the ruling. That, number two, the court assumed the respondent had a right to rebut the evidence. And number three, the court regarded that channel of evidence as vital to its ability to reach a correct conclusion. Back to Kraft, quoting Kraft. Both parties appeared at trial and testified. Neither testified as to the grounds for dissolution. However, they did formally stipulate into the trial record that there has been a breakdown of the marriage so that the legitimate objects of matrimony can no longer be accomplished and that there is no reasonable likelihood of preservation of the marriage. The stipulation is nearly a precise recitation of the factual showing required under the statute. The only testimony offered as to the breakdown of marriage was offered by a neighbor who conceded she had seen little of the parties in the 3 years prior to trial. Not a very good witness, not a very strong witness, was it? This witness testified she believed the marriage had broken down so that the legitimate objects of marriage could not be achieved and there was no likelihood of it being restored. The witness testified she believed the marriage had broken down. Notwithstanding his stipulation may have precipitated the oversight, respondent now claims there was a failure of proof of marriage breakdown. We disagree. We believe, however, such a stipulation is corroborative evidence and may be considered in connection with petitioner's showing. In the instant case, the case at hand, petitioner's showing otherwise consisted only of her neighbor's testimony. Respondent argues this was insufficient in the belief the petitioner should personally be required to testify. We hold a petitioner may make the required showing of marriage breakdown required by point 7 and point 8 by any competent evidence and need not personally testify. Okay. My response to the craft. The value of craft is as a precedent is not only that it has never been overturned and that it is based on Iowa law, which remains unchanged, but also because Kraft said anything else, because had Kraft said anything else, its precedential value would have been at the expense of the authority of Iowa law, because what Kraft said about the requirements of Iowa law was absolutely, undeniably, irrefutably correct. And it would have been just as correct had not Iowa Code 598 not been so crystal clear, because in no other area of law would the testimony of a single party to which the other party was not allowed to respond be acceptable as sufficiently dispositive evidence, in other words, evidence that settles the matter, to support an irreversible ruling. So then, how has it been possible that dissolution jurisprudence since 1970 seems not to have noticed any evidence requirement by the normal meaning of the word evidence? There's one explanation. The legitimate objects of matrimony have never been defined, creating confusion about the nature of evidence concerning them, and reducing the explicit requirements of Iowa law to mere lip service. I find the phrase in no law dictionary. I find this phrase directly connected with any definition in no case, except in Kraft, where it is loosely associated with number 1, children, number 2, property, and number 3, the proper moral order and peace of society. These are truly legitimate objects of matrimony, and other case law offers more. The closest we can come to a definition in law dictionaries is to examine the words separately. Black's Law Dictionary, 4th edition, the edition which was current when no-fault divorce was enacted in Iowa in 1970, defines them legitimate, that which is lawful, legal, recognized by law, or according to law. Objects, the end aimed at, the thing sought to be accomplished, the aim or purpose, the thing sought to be attained. Matrimony, marriage in the sense of the relation or status, not of the ceremony. 2 years before Kraft, another Iowa appellate case recognized the right of parties in a dissolution to contest the dissolution with evidence. Here's what the court case said. In the present case, petitioner's irreparable breakdown of marriage evidence was amply corroborated by several disinterested witnesses. Wow. The court let him contest the divorce. Additionally, respondents' testimonial statements alone tend to strengthen and confirm petitioner's testimony, which clearly discloses the legitimate objects of the involved marriage had been irreparably destroyed. Illustratively, respondent voiced a doubt as to whether he was still in love with petitioner or that there existed any future in the marriage relationship. What's that? Respondent in love. Oh my gosh. Had it been the respondent to the divorce petition who doubted out loud whether he was still in love or whether there existed any future in the marriage relationship, I would argue, and do argue below, the statements on that level are not dispositive evidence of marital breakdown. But I can see that when the one fighting for the marriage says them, that weakens the argument. I found only one other case where a U.S. court ruling on laws similar to Iowa's acknowledges the right of a respondent to a dissolution petition to contest the dissolution. That court, ruling earlier this year, affirmed that right. A lawyer's license was suspended because she failed to contest the divorce as her client had desired. In her defense, the lawyer argued, as perhaps any Iowa divorce lawyer would argue, that her client's request was properly ignored because they were under no-fault divorce laws where one cannot contest a divorce. The Welcome is the name of the lawyer. And this is the, and I got it, it's not, I wish I could tell you it was an Iowa court, but it's the only contested divorce I could find anywhere, and this was in the Virgin Islands, still a U.S. court. And still, it had the same kind of laws as we have in Iowa. So anyway, the attorney's name is Welcome, and here's what the ruling against her says. Welcome contends that her failure to contest the divorce did not harm her client because the United States Virgin Islands is a no-fault divorce jurisdiction. Parties are divorced even when one spouse objects to the divorce. The court case is called Suspension of Welcome. S. Court Civ number 2012-0094, opinion of the court. Now, in explaining why not providing that defense was so serious as to merit suspension, the court's explanation of what the law says is an accurate description of Iowa law. The court said, "This is a highly misleading representation of the law. Every plaintiff to a civil action may obtain relief over the objection of the defendant if a court finds that the plaintiff has met his or her burden of proof on the asserted claim." In other words, the court is saying, look, this is the way all civil cases are. The other side gets to say that the first side is wrong. And shouldn't get what the first side wants. Everywhere. What kind of exception are we making for divorce? It's basically what the court said. But the court continues. No-fault divorce does not mean that a party can dissolve a marriage at will simply by filing the appropriate document with the court. The petitioner must still present sufficient evidence, quote, that there has been a breakdown, that there has been a breakdown of the marriage relationship to the extent that the legitimate objects of matrimony have been destroyed and there remains no reasonable likelihood that the marriage can be preserved. The court quotes Black's Law Dictionary, defining a no-fault divorce as an action where a party must make a showing of the irretrievable breakdown of the marriage or irreconcilable differences. The court continues, even if Welcome believed that Richardson was highly likely or even certain to fail in any attempt to contest the divorce petition on the merits, it is so fundamental as to not require a citation that it is the client and not the lawyer that is vested with the ultimate decision of whether to settle a civil claim. I have found these three cases that affirm the right of a respondent to a dissolution petition to contest the dissolution by presenting the evidence. I have found no precedent to the contrary. If there is a precedent to the contrary, it would be fascinating to study how it deals with the crystal clarity of Iowa law that the parties do possess that right. I realize what force of habit I ask this court to overturn. Although law and Supreme Court precedent, that addresses the points that I raise, is for me, the habits of dissolution jurisprudence at the trial court level is overwhelmingly against me. I also know that judges and lawyers don't like the fragility of marriage bonds since 1970. Judges complain about it. Many of your own families have been torn by it. But the power of habit, even when it is a habit that is bad for everybody, is so great that even the Declaration of Independence acknowledges it. It says, "All experience hath shown that mankind are disposed to suffer while evils are sufferable, than to right themselves by abolishing the forms of which they are accustomed." I realize it is much more comfortable and familiar to curse the darkness than to shine in it. But I appeal to you, Iowa's family bonds desperately need the light which Iowa law authorizes you to shine. Addressing the judge. Now let's see if we can define what it means to say, have been destroyed and there remains no reasonable likelihood that the marriage can be preserved. First I want to sing a little bit more of my song here. Second verse, parents play, children pay. Sold the house, moved out of town. Apartments don't have dogs around, just quiet. Visitation Christmas Eve, cry when clock says time to leave, can't fight it. When parents play, children pay. When parents stray, children pray. One of the saddest things we see today, the home where parents play and children pay. Judge says you get custody, I can't judge morality, go play now. I can look at all you've done to your kids except pulling up their anger. Parents played, children paid. Parents strayed, children prayed. One of the saddest poems there is today, the home where parents played and children paid. The statement about irreconcilable differences is often equated with, the statement that the marriage cannot be preserved is often equated with irreconcilable differences. But every human relationship has a few irreconcilable differences which are outweighed by the considerable and undeniable benefits of the relationship. So the fact that a difference is irreconcilable cannot justify severing a relationship unless the difference is not only irreconcilable, but it also significantly destroys the legally recognized purposes or legitimate objects of the marriage. In fact, many relationships are built on differences, according to the adage opposites attract, which is as generally accepted a truth as the benefits of having things in common. Relationship experts commonly describe how one is attracted to strengths in another which complement one's weak areas. That's where the balance comes in. It creates a rhythm where one feels whole while being with the other. Each individual soul feels it, hence the feeling of completeness. I have found my soulmate. This is proof of God's design at work. The two, they are two, they aren't one. The two shall become one. At any time throughout the marriage, many pressures in life can cause stress on that oneness, and spouses may unfairly assign blame upon the other. Their differences can become annoyances. As the family grows, spouses get pulled in many directions with various different responsibilities. The needs of each spouse may get neglected in the struggle to juggle. The differences once valued for complementing each other can seem, when unjustly magnified, to be evidence of destruction of the peace and harmony of the marriage, and consequently the differences can get labeled irreconcilable. The appearance of irreconcilability is compounded by the various temptations common to all men. 1 Corinthians 10:13 says that no temptation hath taken you but such as is common to man, common to all men. Like examples of overemphasis on money or unhealthy behaviors. The structure the marriage was built on can get turned upside down. But none of these differences are irreconcilable, however weak the flesh may be, if the spirit is willing. Matthew 26:41. Solutions include prayer, self-reflection, use of an expert in marital relationships, confession, and perhaps most of all, forgiveness. Forgiveness. Stressful. Tell you what, there's no better way to relieve your own stress than to forgive. Stressful periods in any given marriage are not dispositive evidence that anything is or had been destroyed, or that all facets or bonds of the marriage are or were destroyed. Multiple pressures can lead a normally well-meaning spouse to throw in the towel. In their stressed state of mind, they may become convinced that they do not have the time or the resources or the money to facilitate such an overwhelming endeavor as counseling. On some level, their behaviors and choices may even persuade the other spouse to internally agree. Ironically, this is a perfect example of their oneness or their like-minded thinking. Many kinds of differences can crop up in the course of decades-long marriages. Sometimes the role of spouses as partners breaks down as one spouse takes control and assumes the role of carrying all the burdens by unconsciously or consciously excluding their spouse in matters of importance. This can result in resentment from both, from one for being excluded, from the other for being overburdened. Perhaps maybe I'm at fault. I will welcome help. With the right mixture of lawyers and maybe even judges, divorce begins to look like a way out of complexity, although of course it doesn't necessarily solve problems. It definitely makes them more expensive. Peace and harmony. Peace and harmony can be derailed many times throughout the life of a long marriage due to unforeseen obstacles such as death, job changes, financial strain, health issues, accidents, child rearing issues, etc. Through prayer, love, dedication, passion, respect, patience, humility, support, and forgiveness. Any two spouses can find a way together to survive these trials and tribulations. In long-time marriages, the sheer number of years spouses have dedicated to each other to the marriage is enough evidence to prove that the bonds of matrimony have not been destroyed. My spouse and I are living proof of this. Any married person can attest that marriage is not always easy. Periods when it is not easy are not deal breakers. If the marriage has survived these on-again, off-again highs and lows, Iowa law makes these kinds of issues relevant to the gathering of evidence of whether there is, in fact, irreconcilability. It may be that a wise judge can discern solutions for problems which the spouses have missed. Iowa law gives him authority to propose them if he discerns any. The next section is irreconcilable differences and incompatibility. Before we get to that, I just want to repeat myself here. This arm on this chair makes it difficult to put this guitar in the right position, but big brown house family, mom and dad, a brown puppy, 4 children. Mom wrote books, dad taught in school, kids grew by the golden rule, child heaven. The parents play, children pay, parents stray, children pray. One of the saddest things we see today, the home where parents play, children pay. Don't get off track trying to get your children back. Preach the gospel. Actions just get in the way. Laws won't help. These latter days are awful. Christians sleep, demons scream. Lovers leap, children weep. Families are under siege by policies which undiscerning Christians chase like sheep. Irreconcilable differences and incompatibility have never been listed in Iowa divorce law, but they are very much a part of the mindset that once one spouse asked for divorce, that's all the evidence you need that the legitimate objects of matrimony have been destroyed, making the additional evidentiary requirements in Iowa law a bunch of nonsense. Even though these phrases are not in Iowa law any more than rubber stamp divorce is, it may be important to address these concepts because they are thought to be synonymous with destroyed legitimate objects of matrimony. What do the words mean? Do they have any more objective, measurable meaning than the word bad? Do they enable two different judges to agree whether they exist in one relationship but not the other? Here's a 1952 case from Birch versus Birch. Incompatibility of temperament does not refer to these petty quarrels and minor bickering which are but the evidence of that frailty which all humanity is heir to, but it unquestionably does refer to conflicts in personalities and dispositions so deep as to be irreconcilable and to render it impossible for the parties to continue a normal marital relationship with each other. Well, now the first part of the statement is profound. It confesses that there are quarrels in every relationship. That's normal. We might add that the quarrels in every relationship reported to strangers by one of the spouses, along with that wee bit of exaggeration to which humans are prone when in a complaining mood, can sound cruel, horrid, and barbaric, if not criminal, to a stranger forgetful of his own occasional cruelties to others over the decades. I will confess that I have betrayed my spouse in this way, in weak moments, and he has confessed such to me, a failing which I am determined to overcome and for which I beg his patience. The second part of this statement, though a little closer to an objective criteria in the absence of any legal standard for what is normal, raises this question. Can any two personalities bonded for 30 years in marriage who have blessed society with this is a sample brief, with wonderful sons and daughters who have not significantly changed since day one, be judged to have such deep divisions as to suddenly make the marriage relationship impossible? Was the Third Circuit Court unwise to adopt such a definition? Are popular assumptions wiser, that irreconcilable differences are evidenced rather by the kind of emotion all adults have from time to time, which in a child we would recognize as closer to a fleeting tantrum than to the careful reflections of a thoughtful adult? Does the verbiage of Iowa Code 598 give a court no jurisdiction to hear evidence whether a spouse's desire for divorce might not proceed from the nobler elements of his personality, but might even be contrary to that spouse's own best interests? And upon sensing that might be the case, has a court no influence through either its persuasive wisdom or its orders to encourage more sober reflection upon the decision to destroy the family bonds? Indeed, couldn't it be that the legislature, in requiring courts to hear this evidence and soberly assess any alleged destruction of the legitimate objects of matrimony, realized that courts have one powerful tool unavailable to counselors and pastors that might be of great help in overcoming mental log jams? The power to compel people to answer questions during cross-examinations. Think of the power of this tool to pressure an adult to think through questions which have been avoided. Why, it might even be that I myself, subject to such a process, might be shocked at the cobwebs exposed in my own synapses. This power of the court is one reason there is wisdom in the warning of a court. that the requirements of law are not satisfied by making a simple case of incompatibility of temperament a contest between psychiatric experts plumbing the depths of the unconscious qualities of the parties. That quote, that wonderful, I love that quote, came from Shearer versus Shearer. I don't have the year. 356 F second, page 391. Further warning against leaning on psychiatry for more wisdom than anyone already has by virtue of being human comes from the U.S. Supreme Court in William Daubert. Supreme Court case in 1993. The case has been used to reject practitioners of pseudoscience masquerading as expert witnesses. An example of pseudoscience was the theme of a book by Karl Popper, whose summary was quoted in Daubert. Here's the quote in the Supreme Court had. The criterion of the scientific status of a theory is its falsifiability or refutability or testability. The book was titled Conjectures and Refutations, The Growth of Scientific Knowledge. It explains how psychology is a pseudoscience, more like astrology than astronomy, because it does not make predictions about an individual which are falsifiable. Popper wrote that the impressive thing about Einstein's predictions is the risk involved. If observation knows that the predicted effect is definitely absent, and then the theory is simply refuted. But it was impossible to describe a human behavior which would be accepted as proving psychology false. The responsibility of courts to carefully weigh the evidence for and against whether legitimate objects of matrimony have been in fact destroyed is described in an interesting book published in India, which explored whether our laws might be a fit model for their laws. Although the book was written well after 1970, and after all states had turned their divorce laws into rubber stamps, so far as I can determine, it is written as if the evidentiary requirements of no-fault divorce are routinely met. Perhaps the author just read the law and assumed they were. In any case, his point is well stated. He says, thus, some courts may find or have in fact found incompatibility in situations which could have been overlooked as wear and tear of conjugal life. Others have applied stricter standards. A heavy responsibility no doubt rests upon the court. It should go into the whole history of the marriage, extract full evidence of facts, weigh the probability of reconciliation, and examine the extent to which the objects of matrimony have been frustrated. The book is called Marriage, Breakdown, and Divorce Law Reform in Contemporary Society. A comparative study of USA, United Kingdom, and India. Well, let's come back to legitimate objects of matrimony in Iowa case law. Quoting from, or referring to Kraft versus Kraft, the 1975 case, which listed as legitimate objects of matrimony the children, family, finances, and the moral order and peace of society. What if the person contesting this divorce, if they've been married 30 years, maybe their children are all grown, so they don't have the children as a legitimate object of matrimony in their favor. So here's what they could say in that case. I will just touch on this legitimate object of matrimony only briefly because it is only marginally relevant to our case, since our children are adults and we have grandchildren. There is considerable research documenting the harm to children from divorce. There is so much of it that its existence is common knowledge. Less research is done on the effects of divorce on grandchildren or on adult children, but the research documenting the harm to children living at home should establish the probability that whatever its effect on others is not positive. Although adult children are already raised, parental influence, good and bad, does not entirely cease. Although grandchildren have parents to raise them, grandparents likewise have an important legally recognized role as recognized in Iowa Code 598.35, which is titled Grandparent Visitation Rights. Now, in custody battles, the best interests of the children trumps the interests of the parents. This ought to be the case not only in custody battles, but in the consideration more important to the children, establishing whether granting the divorce is in the best interests of the children or the grandchildren. After all, if, as the Iowa law says, the best interest of the child is defined as the maximum continuing physical and emotional contact with both parents, shouldn't there be serious evidence of marital breakdown before dissolution can be ruled in the best interests of the child? Although the tragedy is not as grave when the relationship with grandparents is halved by divorce as when the relationship with parents is severed, an anchor in a child's life is lost when grandma and grandpa can't be visited at the same time in the same place, and later when the title is passed on to strangers, and later when the child wants to figure out his family tree and he has trunks divided into branches that stay there only for 3 or 4 years at a time and then have to be lopped off and crafted in a new one created by the next divorce.